Good morning, everybody. I'd like to talk to you this morning about myths and rumors in personal injury cases. I hear some of these, and I'm sure you've heard a few yourself, and I've narrowed it down to 3 that I'd like to talk to you about today. The first one that I hear most often is, I can't afford to hire an attorney. I've been involved in an accident, I'm not working, I'm paying co-pays and deductibles, I've got all these expenses. How am I going to come up with the money to hire a lawyer? Well, I won't say you're in luck, you've been in an accident, but you can hire me on a contingency fee basis. What that means is I don't charge you anything up front, I don't charge you a flat fee, I don't charge you a monthly billing for my hours that I put into the case. I only charge you a percentage of the recovery at the end of the case. And even then, only if I'm successful in getting a recovery. This also serves a good purpose for society, I think, in that I don't tend to go forward with cases that don't have good merit. If it doesn't look like it's a case where I can be helpful and get a good recovery, I don't pursue the claim. The second myth that I hear a lot is, if I do hire a PI attorney, might I get less out of the case than if I did it on my own? This is kind of a corollary of the first one. That's not my experience, and I don't take cases where I don't think that I can do better for the client than they could do on their own. For example, I don't take small claims cases. You can sue in small claims for $7,500 now on personal injury cases, and as of the first of the year, that goes up to $10,000. I don't handle those cases, and you can probably do those on your own. But in the cases that I do handle, there are some things that I do to help maximize your recovery, including undertaking a complete investigation, preserving the evidence. If you have a product liability case and you don't have that defective product, you're out of luck. You're not going to be able to prove that case. I help to locate all the sources of recovery. If you're involved in an accident, your primary claim is going to be against the other party who is involved in it and their insurance company, but you may also have a claim with your uninsured or underinsured motorist on your own policy. But there could be other factors too. You could have a dangerous intersection that would give you a government claim that you might want to pursue. So I can, and perhaps also you might have a defective product, defective vehicle, and that would provide another avenue that I can explore for you to locate all the potential sources of recovery. I enter into negotiations, I file lawsuits, I do discovery, alternative dispute resolution, trials, whatever it takes to get the best result in your case. At the end of the case, you might be surprised to learn that your health insurance company that's been paying your medical bills wants money back from you if you collect money on the injury case. They put their hand out and they say, okay, we paid $5,000 to your doctors, pay us back. That's something that you're going to owe. With an attorney, you can have those bills and liens negotiated down. I can do a lot of good work for people reducing those amounts so you get more net proceeds in your pocket. Keep in mind that there's no preset value to a case. Instead of getting all of a small case, you might get most of a much larger case. And that brings me to the third one. I heard that my case is worth a multiple of the medical bills and loss of earnings. This is something that I've heard from the time I was a claims adjuster until, well, 35 years of practice as a PI attorney. And it's rarely the case. The reason is that there are a number of factors that you have to look at. One is there good liability? California has comparative negligence, so you don't have to be 100% in the right to gain compensation against the other party. But you can recover for their percent of liability. In other words, if you're 25% responsible and they're 75% responsible for a traffic accident, you can recover 75% of your damages. It's that simple. But it means that it's not necessarily a multiple that's going to help you determine the value of your case. It also depends on the nature of the injury. Some injuries, like scars and fractures where there's no surgery required, are going to have fairly low medical bills compared to the value of the case. The case value is going to be substantially greater than what the medical bills and loss of earnings would be. Type of treatment is relevant. If you have surgeries, burn treatments where they have to debride your skin, very, very painful operations, these will increase the value of your claim, your pain and suffering damages, substantially above the medical bills. You're entitled to recover general damages. We use the shorthand pain and suffering or non-economic damages, but what we're talking about is past and future physical pain, mental suffering, emotional distress, loss of enjoyment of life, disfigurement, inconvenience, grief, anxiety, and humiliation. Now, in some cases, you might have punitive damages, and you have to show oppression, fraud, or malice, but if you can do that, you're entitled to get additional damages that, again, wouldn't be really covered under some multiple of your medical expenses and loss of earnings. There's been a change in the law in California on what you can claim for your medical expenses. It used to be, if you had $50,000 in expenses, you put your hospital bill up and your doctor's bill and your prescriptions, and you put them all on the board or a PowerPoint slide and show that to the jury. And then afterwards you would claim your pain and suffering damages and other losses. Because of recent California court decisions, we can't do that anymore. We can only put up on the board the amount that your health insurance company paid for your medical services, along with your co-pays and deductibles that you've paid out of pocket. Now, you might also have some services outside of your network that your doctor took on a lien. What a lien means is that your doctor has agreed to wait until the claim is done to be paid. It's not contingent. It's not like the lawyer's fee that you only owe if you're successful. You have to pay it in any event, but the doctor will wait until the end of the case to be paid. And what you can claim on those cases under current law is the reasonable value of those services, which may or may not be the amount that's actually billed. You may have to bring in experts to testify to that. You're also entitled to claim voluntary write-offs after the fact. So these are further reasons why the multiple approach does not really help to determine the value of the case. Other factors that affect the value are the reputation of your doctors. Did you get appropriate medical care from the right kind of doctors for your situation? Your attorney, the quality of your witnesses, your own performance at your deposition. When they took your deposition, were you able to explain your injuries clearly? Did they think that you would make a good impression in front of a judge and jury? If that's the case, your case has more value. If not, it probably won't. They also will look at your past medical history. And if you have one, your past claims history. That makes a difference. And if you have a chronic condition, one that's never going to go away, that's going to bother you the rest of your life, also your age and your life expectancy will enter into it. So these are some of the factors that we look at in trying to value a case, and all good reasons why looking at a simple multiple is not going to tell you what your claim is really worth. So these are some of the myths and rumors that I've heard for many years, and I'm sure you've heard some more too. And if you have any questions, I'd be happy to try to answer them.